You don't get to the question of whether there's impacts on a special use permit application until it's been determined that the application is zoning compliant. And in this case, with respect to this amended application, the building code inspector decided it was not zoning compliant. So we don't reach that issue. So I would ask that if you're going to set a schedule to respond, I might like to say something in response to things that council has raised as well.
Would you like to do that in writing?
Yes, if she's going to.
Any questions?
I guess one question I have is, would both sides be able to come up with their, I guess, rebuttals to each other and then get that to us before next month's meeting? Or I'm just wondering the whole timeline here for everybody's sake, because it takes you a couple weeks and takes him a couple weeks and it comes to us and next thing you know, it's December. So I'm just trying to get a sense of where we are, if it's going to turn into January. So.
Well, maybe the first order of business for the board to consider is procedure. So the public hearing right now is still open. It has not been closed. You have a few options in front of you. You could keep the public hearing open. That clearly would allow further submittal of public comments, including from the applicant as well as the building department. You could close the public hearing but establish a written comment period. That would not be exclusive just to the applicant or the building department. That would include additional written public comments. And you can put a timeline on that. I know your past practice, your past procedure has been, in the event you do close the public hearing and establish a written comment period, you set a timeline on that, but we're not getting, or strike that. The zoning board has not in the past gotten into a procedure where there are replies and replies and further submissions. The past procedure of this board, in the event the public hearing is closed and you establish a written comment period, that is one single submittal for a written comment period. And that seems to be practice of the board, and to set a timeline for that. As to when you would then continue with your deliberations, as you know, the zoning board, once the public hearing has been closed, and that would include the written comment period, you then have 62 days in which to render a written determination on the appeal. So you can place it on an agenda for deliberation, but just note that you do have 62 days following the close of the public hearing as well as the written comment period in which to render your determination on the appeal. So those are some procedural things within your discretion to either keep the public hearing open or to close the public hearing and establish a written comment period. I'll note for the record that written comment period was requested by the appellant, was not objected to by the building department. The building department did also request the opportunity to submit further written submissions. And I would presume that there's no objection from the applicant to that.
Yes, so my qualified request for written submission was only not looking to remarshal any of the information in the written submission that I received this evening. If there was anything that was not already responded to, that I would just be allowed to briefly respond solely to those issues, and of course, allowing council to respond to that briefly. But if I found that
So
my submissions were already addressed, then I won't be
sure.
submitting anything.
Now, understand, if there's a written comment period established, it doesn't require written submittals. It's just the opportunity for further submittals if the applicant, if the appellant, or the building department deemed it appropriate. But let's talk procedure for a minute. Is the appellant requesting a period of time in which to submit a reply and then allow the building department to reply to your further submittal? Is that what the procedure being proposed? In other words, if we're in court, this would be a reply paper and then a serve reply.
Right, yes.
Okay, so that So the board understands this has not been your past practice, but it's within your discretion. You can establish a period of time for the appellant to respond to the written submission from the building department. And once that's received, allow then a period of time in which the building department could then submit a rebuttal to the further submittal, the reply, if you will, with the building department submitting a SIR reply. That procedurally is in front of the board. You can consider that. You can establish that procedure. That's within your discretion.
May I be heard?
Certainly.
The only thing I would say is that I think in the past, the procedure whereby you just have the comment period and you respond at the same time, I thought that always worked pretty well. That would be my preference. Of course, go along with whatever the board directs.
Certainly. So that was simply an opportunity for the building department to have in hand the reply papers. The board could likewise simply establish a written comment period, both for purposes of reply by the appellant as well as by the building department, set a date for submissions, and then the record would be complete and the board could then commence its deliberation of the issues. Again, that's within the board's discretion.
So John, when you brought that up, would you like to see that before December? Was that your goal to have these submissions?
Like you indicated, I think usually in the past, we've kept the public hearing open for written comment. If we do that, we're just going to keep delaying that. So if we only set the period for the two sides to gather their rebuttal statements to each other, they get it to us, we can review it. I think that's probably the track we want to go through. At least I think is probably the
It could
track.
be, as a practical matter, understand next week is a very short work week with the holiday, so just keep that into mind and with consideration of both the appellant and the building department schedule.
One thing I was thinking, if we do keep it open until a certain date, we should make sure that 62 days doesn't fall 2 days before our next, some subsequent meeting. You know what I'm saying? Because the one time we had a special meeting, but it was 1 day too short. So I think we have to figure out when the next couple meetings are, make sure 62 days doesn't fall a day or two short.
Right. I'll note for the record that those timeframes can always be extended upon consent of the appellant. If you're a day or two short, it could be addressed that way, but certainly we can look at calendars. So.
So our next meeting is December 16th.
Next one is December 16th.
Yeah. So would 14 days be sufficient amount of time?
It should be.
Okay.
So we're going to keep the comment period open or just say within 14 days?
We'll close the public hearing. We'll allow for the receipt of written comments.
Well, right, and I'll note in the past, the zoning board has established this written comment period. That's for any submittals, by the appellant, by the building department, or by members of the public. We simply are establishing then a written comment period. You can determine the time, again, that's within your discretion.
So you're looking at your calendar.
So if we're doing 14 days from tonight, it would be technically December 2nd.
December 2nd.
Again, simply as a practical issue, is that the Monday following?
It is,
So it's the Monday following the Thanksgiving holiday.
correct.
It just presents getting materials timely submitted
Sure.
to avoid any issue about if it was timely or not. Again, I'm not setting the dates, but those are practical considerations for the board.
Very good practical considerations. How about the night? We push it out to the night.
Sure. 21.
If December 9th is picked as a practical matter, that will give the board 8 days prior to the 17th, and understand the 17th, this could be on your agenda for deliberation. 16th. Okay,
But then we have 62 days from December 9th.
that's correct.
So we could actually also hear it in January.
That's correct.
And they would be submitted to the building department, and the building department's responsibility then to get it to its own board members. Well, we'll close the.
Yeah.
So
So, excuse me, maybe I missed it. What's the date we're supposed to respond by?
We're going to go through that. So
Okay,
what's in front of the board now is the consideration of closing the public hearing this evening and setting a written comment period for receipt of any supplemental written comments by the appellant, by the building department, or members of the public through and including December 9th.
So I make that motion to close the public hearing and then to open a written comment period for the receipt of any written comments. And that was closed on December 9th.
No second.
Thank you, John. All in favor?
Aye.
Aye.
Any questions? No. Thank you. Mr. Choppy, do you have any questions? Okay, thank
Any
you.
questions for Tom?
no, no,
Okay, thank you.
thank you.
So does she have her information? Oh, she have the information that she needs. That is. Oh, and she didn't see this.
Did you say that you this is.
I think so. I think she had. Okay. Yeah. I think
Tom?
He gave her, he gave her a copy.
Yeah, he asked to.
That's a different,
So that's.
that's a different packet that he offered to get.
So he had all the appeal submitted, as well as this is basically what's called the record
Okay,
for the building department.
so that's ours.
That's correct.
Okay, and we gave her.
Yeah.
Okay, good.
So, Mike, what I'm going to ask is, this should remain in the record, but if you could have Wendy scan that, and
Okay.
email it to me, just so I have it as well. Okay.
Next on our agenda is Atlas Renewables, Brunswick and Sickaway Solar, Shitty Lane, Brunswick Road, use variances. Hello.
Good evening. Does anybody need a break before we press on?
Pass.
Okay. Good evening, ladies and gentlemen. Dave Brennan with the law firm of Young Summer out of Albany. With me, again, as usual, is Louis Torrent. And on behalf of Atlas Renewables and Quantum Energy regarding two applications for use variances for renewable or solar energy projects. When we were last before the zoning board, we had submitted a request of the board, an additional clarification on the use variance standard applicable to public utility or renewable energy projects. And we left it last time as additional time was needed to digest that. Hopefully we're getting into an easier phase here, meeting not a harder one, but we've had quite the evening tonight with some topics to, that are more interesting than normal, I suppose. So, I guess I could maybe follow the chair's lead. I can dive right into answering any questions. If you have them, I do have a couple of initial comments or thoughts to share with the board and then see where it takes us. And I defer to see how you want to handle that.
Sure, if you could kind of give us those additional comments that you
Sure.
have.
So when I was turning my attention to preparing for the meeting tonight and flipping back through some of the cases and reading through those, the one that caught my attention, the one that I think is typically, well, there's two that I think are very applicable. One is the case out of Greene County, which was a very comparable provision where it was a solar farm that was being proposed. The zoning board applied the traditional use variance standard, and it went to court, and the court said, no, you should have applied the public utility use variance standard. That one I think is very much on point, but the practical difficulty of that one, as was explained by the board's counsel at the prior meetings, was that came out of Supreme Court, Greene County, and while maybe on topic, is not necessarily binding precedent because it's in a different county, and while maybe instructive, certainly not binding, and I certainly do not quibble with that. But I do think the case is very instructive and is on point. The higher order case is the town of Beekmantown case that did go to the appellate division, third department. That case is higher authority and binding precedent, but was on a wind farm, not a solar farm. But I do think there is, that's a distinction without a difference with respect to the fact that both of them are facilities that produce energy. In that case, the appellate division did say that public utility use variance standard was applicable. But in reading that Beekmantown case, there is discussion in the case that talks about what's the zoning law say? And so we've been back and forth. I've been in front of this board and the planning board over like 3 years, I think. And so I start to worry whether I've said the same thing different ways, different times, or if this is a new thought. But if you indulge me for just a few minutes, I went to the zoning law and I said, let's look at what the town of Brunswick zoning law says about the topic of what is a solar facility in the town, what is a public utility in the town. And so I went to page 30 of the February 2017 zoning law, and it says utilities on a public, any person, firm, corporation, municipal department, or board duly authorized to furnish and furnishing under state or municipal regulations to the public electricity, gas, communication, water, or sewer. And in my mind, the town's own definition of what is a public utility clearly covers what Atlas and other renewable companies do. So I think that is some additional basis to focus on that when we're talking about a public utility, the public utility use variance standard ought to apply. I also focused on page 26, the definition of solar collector system commercial, very comparable. But it talks about a utility scale, solar use may include solar energy systems, equipment and uses, etc. Within the definition itself, it talks about utility scale. And so primarily what I'm suggesting is the public utility definition within the town's own zoning law, we're within the four corners of that definition with what we do, which is produce energy and sell it to consumers. And so by extension, the correct variance standard applies to public utility use variance standard.
Do you sell directly to consumer? You sell to,
There will be this is more of a Lewis question, so I like to, I always bring people to the meeting and then all too often I let them sit there and not speak. But we do have, let them talk about this.
It is provided by the Public Service Commission. So we transfer the energy to, in this case, National Grid, and National Grid distributes the energy. The customers, it's through subscription. So, but from customer point of view, yes, it will be invoiced by national grid, it will be invoiced to national grid, but the concept here is, it's not an isolated part of the system, it's part of what the Public Service Commission considers the electricity grid.
So there are, as I understand it, there's subscribers, and there may be one subscriber, you may have, in some cases, there's stories, a school district may subscribe to the entire production of a particular project and take up its full capacity, or in many other cases, it's really kind of mom and pops, it's house by house, user by user, but at the end of the day, you are subscribing to the energy produced by that particular facility. So I just wanted to add that wrinkle to an already, long night, is that I think there's support in the zoning law itself for the idea that we are under public utility. The definition itself is, a little bit more broad sometimes than you see. It says a person, a firm, a company. It is broader, so it does encompass, where in some cases, other definitions and other codes may be a little bit differently worded with respect to what is encompassed within a public utility under the town's own zone.
So I guess the question would be, if a person has solar panels on their roof, are they a public utility?
No, because you're not,
But they're a person.
In person.
they're not furnishing electricity.
To themselves.
They're not furnishing electricity to the public. You may have it on your roof for your own use, but you're not.
Correct. I actually have them on my roof, and my excess goes back to the grid.
Yeah, as an offset of your electric bill, under net metering.
Yes. Actually, you're not selling electricity, you're receiving credits for future use.
Okay.
So, at the end of the day, maybe not today's day, but at the end of the day, we have to get to, I suggest, we don't have to do anything, I suggest that what we're looking for is an initial determination by the board as to which standard it's going to apply. I did speak briefly with Mr. Gilchrist this afternoon, just a little update before we hit the room here tonight. And, that was the discussion. I certainly don't think it's the right approach for us to put in proof for both standards. I think that complicates the matter. It's not the way to go. I think it's initially to the board. And I certainly, I guess I can take the approach of we'll just submit one. But I think that is not really an efficient use for us to pick which one it is and say, okay, here's compile all this information, submit it, and have the board go, well, we like the other, we think the other one applies. Thanks for putting this together. So we are looking to the board to make that initial threshold decision. And then, we're going to submit based upon that. It's, I guess an important point is it, in a nice way, it doesn't go away with the decision. It just focuses on what we're going to submit as to proof.
So if it were to be considered a utility, who would regulate it?
The Public Service Commission. So, and this is laid out in the information we submitted. It is, and of the different things I'm good at, reciting that is not the thing that comes easiest to mind, but it is regulated, and there are provisions that Atlas and other companies have to follow in having a distributed generation facility, how they interact with the public.
What else does the public service regulate?
Step back into what else is the Public Service Commission regulate?
Specifically for solar farm?
No,
Or
in general.
All the utilities for gas, communications, and electricity, and water.
Oh, I'm sorry, I misunderstood the question. So Public Service Commission, that one I could have answered a little bit easier, I'm sorry. So Public Service Commission regulates water, sewer, electricity, telecommunications, electricity and gas, cable TV, are the ones I can think of. On the water and sewer, it may be more limited to private, what I call transportation corporations and not municipal as much, but on that one, I don't typically see. And the city of Troy water system is regulated by the PSC with respect to rates. It's never seen that way.
So across the country, there is no other regulation of the solar by the Public Service Commission?
I'm talking about the New York State Public Service Commission, it's not.
Right, so I'm just asking a different question then.
Okay.
So we'll bring it out a bit. So the Public Service Commission does regulate solar in other states?
I do not know how other states are regulated. I have my suspicions that it's.
As far as I know, the body that regulates in the state of New York the public utilities are called the Public Service Commission. In other states may have different names, but the function is the same. And all these state by state are regulated at the federal level, at the Federal Energy.
I think that's what we're looking for, is what is the federal agency that oversees the Public Safety Commission?
Is the federal, FERC is Federal Energy Regulation Commission. That is getting above my pay grade. My sense is there is no FERC component of a distributed energy solar project. And that's my, I can dig into that one more, but I have not heard that there's FERC components. I think the ones that I'm aware of are the ones that are like hydro dams, like in Cohoes at the Cohoes Falls, those sort of major generating systems are at the FERC level, but not these smaller ones.
So it's generating this line of questioning that I have. To consider solar facilities utility, it sounds like you're giving this form of energy production like a carte blanche to go anywhere, to do anything. So that's what I was asking, like how is it regulated? Who regulates it? Not how, but who regulates it? But I guess we can look at it just this one example, or two examples, the Shibby Lane and the Brunswick Road being filed under utility. So then they would get, by going this route, you would get your place in the line, like the queue of, having access to those substations. So I guess I'm just trying to clarify in my own brain, allowing the solar production facilities to be termed under utility. So utility kind of comes from like things that we use often, right? I mean, I guess like the Latin root word for utilize and utility, but it wouldn't be, right? Because I guess it would just be for these two solar projects. But then other solar projects are in front of the board, they would also be considered utility if you were to now make this precedent that these projects can be called utility. Am I confusing you? I think I am.
You are.
Well, it opens up it opens it up to the other solar projects that we have in front of us.
Well, it does, it's not carte blanche though, the standard is not without standards.
Which need to be met.
That need to be met.
Right,
So
right.
it is choosing between two different standards, as to what applies.
Oh, that's interesting. So we're choosing between two different standards of how they'll be regulated?
No, of the, for the use variance. Okay,
Right,
so
that's
let's
right.
stop back. So we're applying because these are in the residential district and solar, large scale solar is not allowed.
Right.
It's allowed in the, what I'm gonna call the AR district, what I generally consider the eastern part of the community. And so if we were there, it would be, simple is the wrong word, but a more simple process in front of the planning board, I believe, just for a special use permit and site plan and connection.
Right.
The difficulty becomes is that the town, and it's not incorrect at the outset, you chose to use traditional zoning principles and said, okay, we're going to, when we divvy up the town into districts and we say, okay, a big list of uses, what goes in each district, we think that solar should go out, in the eastern part, or, some would call it the country, the more or less developed portion of the community. And, on a traditional zoning, how you divide things up and place things, that makes some sense. There's more land, there's bigger fields and things like that. The problem is that the grid doesn't support that. And so, the idea is, yeah, there's plenty of land out there, and if we could just simply build it there and plug it in, we would never be undertaking this. The problem is nowhere in the eastern part of the community can we plug in a solar farm. So you're basically at the impasse of, you don't have solar in the town. We don't have opportunities to put solar in the town. So then we come back to do what we're proposing is a use variance. But it's not carte blanche. It is that there's a balancing test that goes into it with respect to basically the I'll call it generally balancing impact on the community. And where, I keep preaching to Lewis, our clients, is it's about location, location, location. We've got two sites that are well situated. So when you run the balancing test and say, should we allow this? One of them is in the woods, it can't be seen from anywhere. The other one is in a nice hollow, it can't be seen anywhere. So as far as the precedent goes, the precedent is they live or die on their own merits and through a balancing test. And so the next one that comes in that's visible to everyone is not required to have the same result. You may say, okay, we have to process it under the same standard, but the result is not necessarily a yes, it is a process with a decision.
So when you say that they can't be placed in a further distance away from, let's say the grid's plant, the applicant they have to build the infrastructure for that, correct?
Well,
The economics crash the program. So
the
this
other
was a couple of years prior to the moratorium, the discussion that we showed the map of the town of Brunswick, we showed with the birch group.
I remember that, but what I'm saying is it's the option of the applicant to build the infrastructure that would allow these to be placed further out away from the plants, correct?
Strictly speaking, it's national grid infrastructure, so I cannot touch. It must be national grid, and the national grid standards and the national grid cost. So up to the square one, the economics doesn't match.
The economics doesn't match to do that. So, and going back to what the chair had, because I'd had this in my head and I was going to ask the question for a while. We obviously have a few of these projects in front of us. I guess at what point is there any type of study done by National Grid to determine how many we can allow into their substations?
We share some emails back and forward with National Grid about the economics of $1 million approximately for 1 mile of.
No, I'm saying the capacity of the substation. So we've heard in the past to this board that the National Grid substation on Hillcrest is near capacity. So if it can only take one more project and we have 3 in front of us, I guess the question is, where do we get the information from that substation is at capacity and can't no longer take it? Because if we allow all 3, what do we do then?
That's a fantastic point. We can provide you an update, the status of the public information that National Grid provides each of the substation within the town of Brunswick. This is a picture as per today. I cannot promise you that the state of New York will not enhance the infrastructure, and in 5 years there will be an additional 20 megawatts. So if you want, we can also provide you some studies about what are the goals for 2030 and what are the goals for 2040. There are some discussions that, the state of New York is done with solar, they have reached all the goals. That's completely false. That's completely false. And what we can see is that the state of New York is pushing to try to get this 70% by 2030. So As for today, I can provide you a picture.
No, I understand that. I'm just saying that if we were to approve all three of these projects and then National Grid says that we don't have the capacity to accept that, then two of the three projects sit idle.
What I can promise, or
That's my concern.
what I can confirm is that National Grid works in a queue. First who applies, first who get a slot reserved for that project, because these are projects for 2021, and we have paid in full. And part
So
of the
they're already
presentation
reserved.
that Mr. Laverge's request was the Form K, which is the approval from National Grid, confirming and have paid 100% of the cost. We are the queue, so we reserve our slot. If we withdraw these projects, maybe then there will be additional capacity. But at this moment, if I'm getting your question correctly, is that, hey, now we approve these projects and you go back to National Grid and National Grid tells you, sorry, there is no capacity. No, the process is vice versa. We have secured the capacity with National Grid, we have paid 100% of the interconnection cost, and now we are presenting this case.
So every project that comes before this board has already gotten approval from National
I
Grid.
cannot promise what other people does.
Well, is that part of the standard? Is that part of, like, the commission
At
to
least-
oversee
at
that?
least-
Or where does
But
that
this
come from?
is how it works.
Okay.
What other people, I cannot say.
Okay, so for your project, you have that. You're all set. Okay.
So I have a question, and maybe this is pretty simplistic, but if the substation is full, okay, you do your projects, and now that substation is full. What does that mean if somebody has 100-acre, lot that now they sell to put in a subdivision? And that would be the substation. Is there no, because I don't understand electricity that much. So, is there no capacity there for that development?
I don't know if I get correctly your question. There are different levels of solar projects.
No, I'm not talking
No,
about
she's
a
talking about
solar
use.
project.
She's talking about, are you cutting off use for?
Or if somebody
some other
wanted
thing,
to put in, had 100 acres, and
Future
now they
development.
want to sell it off as a development, put in a housing development.
But maybe this person wants to sell the 100 hectares to a solar
yeah.
developer.
It's a
No,
different
to a
question.
housing
She's saying
development.
is if the substation's full with our project connected to it, and someone comes in and says, hey, I want to build, trying to pick something that's not, but a subdivision.
Right,
My subdivision it's 100 acres, it has 120 new homes in it, each home needs so much energy for the year. Does that mean that there's no more users that can connect to it, or is it, in a sense, you're saying, can users of electricity still be supplied, or is it?
I got the question.
yeah, how do they connect to it?
Well, it's the opposite, because we are injecting to the substation, the houses are taking from the substation. So, and this must be a balance. You cannot take more than I can inject. What National Grid is telling me is that, hey, you cannot inject more than X. If
Okay.
the substation has 20, I cannot inject more than 20. And similarly, if in the future there are more and more and more houses that requires more than 20 megawatt, let's say, then National Grid will have to extend or expand the substation.
So they still have to expand the capacity.
Yes, but these are 5, 10, 15 years lines.
So what is an input, how much can go in, and what is an output?
Right.
So it's.
So the drain doesn't matter, the input still needs certain capacity no matter what,
Okay.
because if there's no drain there, you're still gonna,
Okay,
oversupply the substation, right?
That's true, but that's the beauty of this grid and this network, that part of the capacity injected here will flow maybe to the city of Troy, and vice versa. Maybe the capacity injected in the city of Troy goes to the town of Brunswick, and vice versa. From the city of Albany will go to the city of Troy. So it's interconnected.
So does National Grid look at expansion in two ways, where they're gonna expand their power stations versus expanding the infrastructure to allow the solar farms to be placed further out? you know, if they have done that before, the balance of, hey, do I invest $3 million in the substation? Or do we invest $3 million in 3 miles of transmission lines so that these facilities can be built further out for them?
Well, National Grid takes the approach of which are my customers, where my customers are located. The residentials, the commercials, the industries. Okay. For National Grid internally to justify an investment, they have to, for 100% certainty, knows that this will happen. They will request more demand. National Grid will never extend 3 miles because maybe someone wants to connect a new solar generator. Okay, they will tell me, you pay for this $3 million and you extend if you want to connect there.
So they would put it on you as the applicant or the developer to build those 3 miles of transmission lines. Okay.
They will build, but I will pay.
Everybody did.
I just have a question. So what would be the implications on a town zoning board to use the standard for utility?
You said that we
What are the implications on a town, on any town zoning board? They have to choose to use the standard of utility.
have already approved.
I mean, we have done this in the town of Binghamton, gone to their zoning board and had them apply the public utility standard in a very comparable case where there wasn't capacity in the substation. We went through the traditional public hearing process and heard, in that case, you know, some minor comments from neighbors who, once they saw the details of it, were, I would say, more than largely satisfied because there wasn't an upswell of public opposition to the project, again, going to this location, and it was approved. And like many good things that I do, once I get them approved, I don't necessarily always hear when it's built, but, you know, it's in the process of going through to get built. So the implication to the town, I think, is, you know, I believe that the public utility use variance standard is the correct standard to apply to these cases, but then you go through a very traditional process of what is kind of an environmental or impact type review. You still have a seeker obligation, you still have a public hearing, you still hear from the public, and we still demonstrate, and we have hit on these things in prior years, and we will dust them off. And typically, it's about visibility and aesthetics, and so that we demonstrate that, and we hear from the public, and then the board has to make a decision based upon the record before it.
So the zoning board is not the last step. And if the zoning board approves this public utility standard, then we have to take this project and go to the zoning board of the village department. And so it's not like, okay, because this public utility standard applies to this project, bingo, the project is automatically approved. No. I have to go to the planning board, and maybe the project dies in the planning board because there is a problem with the visual, because there is. So, back to your question, and what about the rest of the potential projects that may ask to apply? Well, the same process. I mean, they will have to go to the planning board, and if this is a project in the middle of a residential area with a lot of opposition, and the applicant is not able to provide comfort with setbacks, with visual screening, the project will die.
Thank you. Any other questions or comments?
I don't have any.
Thank you. So the bottom line is, which standard will the zoning board apply? Do you feel ready to?
I was.
Okay.
Thank you. One of the things that came up tonight, and I think factually, it's relevant for the board to consider on this questionable legal standard is, and I cannot recall which member raised it, but the issue of who are the customers. And we heard the term customer and we heard the term subscriber. And I think factually, it would be helpful for the board to clearly understand that side, if you will, of the business. There are subscribers, but it's National Grid that invoices the customer.
It's provided by NYSERDA. NYSERDA is the New York Energy Research and Development Authority, and it is a process that they.
And that's okay, but those facts need to then be put into the analysis of which legal standard, because it is relevant under the case law, we think, to take a look at, is the service being provided to the customer? And the more information we can get on how that side of the business works, to be able to assist in determining what legal standard applies. You know, obviously, this is under the public necessity element, right? You're required to render safe and adequate service. And the cases do say the effect on utilities customers is a significant factor to be considered. So if you can give the board a further submission on that, how that, what's the business model, if you will? Who is the energy sold to? Who's the customer? What's the subscriber? Who invoices? Those facts can then be determined to reach the conclusion of, does this meet what's required for purposes of application of the public utility use variance standard, or doesn't it? And if it doesn't, then it would be a conclusion that the regular standards apply. And I think it's fair to request that the board make that determination so that the procedure, the record creation can continue along that line. We may disagree on what legal standard applies, and if that's the case, that's okay. Someone will ultimately decide, but that fact information, I think, would be helpful for the board. And someone did land on that question early, who's the customer? And it was a good one, and I think it's a relevant one. So if you could get that in as soon as possible so that we can get this issue resolved one way or the other to move forward.
And the board is okay, we'll provide as well some information on the Public Service Commission as related. It is, in our experience, was very effective in the Binghamton that clarified some ideas. That
Sure.
It is a complicated world, the electricity and the regulation, so we'll provide us much detail on size and also.
Good. Actually, that'd be helpful for her.
So following up on the last application, was it Monday the 9th?
Yes.
That we were looking to get things in to distribute to the board?
Right.
Yeah.
Yeah, I think with that, we'll have no problem
Okay.
using that date or better, I would say.
Thank you.
Okay. And then the next meeting is then the 16th?
16th.
Yes.
Okay. All right. Well, everyone, enjoy your Thanksgiving. Thank you very much.
Thank you. You too.
See you the
You
next
too.
one. Thank you.
Thank you.
All right, the Patience Award goes to 22 Grange. Hello there, how are you? So I'm going to ask you to give us a brief overview of your project. What we're going to do tonight is look at the application that you have submitted to the building department to see if it's complete for the purpose of holding a public hearing at our next meeting in December. So that's kind of what we're doing in a nutshell right now. Thank you.
Good evening, everybody. My name is Wayne Kiefer, my son Andrew. I have no idea what I'm doing right now, sitting here. So it's like to get in front of you to get educated.
Sure.
I've been a builder for 39 plus years and done a lot with building departments, but never nothing with zoning board. A year ago, September, we purchased 22 Grange. 22 Grange was dilapidated, sitting there. A friend of the family was trying to sell it. We've seen some opportunity to turn it into a single family home for my son and his family. Quickly came to the town to learn a little bit about what can and can't be done. We were led to believe that we could restore it as is. During the process of restoring and opening up this house, we found that the backside of the house had dilapidated existing addition in the back. So we're attempting to expand that addition, not expand it further back, but just to a second floor. The rear addition that sits there at this moment needs to be removed. It's completely deteriorated, and the foundation is failing. So within that, working with Mike, we've gone to our architect for his suggestions and had stamp drawings created, showing a small addition on the rear of the house, and expanding the wraparound porch to the east, rebuilding it to the frontage. The frontage was already there existing. So we applied for building permit a couple weeks, 2-3 weeks ago, and we learned through that process that the building permit application for rehabbing in addition at 22 Grange has been denied, as this residence is located in a business light district. That's where the complications come in my mind. You know, we have a resident to the left, we have a resident to the right, we have a resident in front of us. It's an existing originally a single 1870 farmhouse. That somewhere along the line was changed into a 2-unit apartment house. We're looking to beautify Brunswick on 142 there and turn it back into a single family home. And, we're looking to learn anything we need to learn to be able to possibly have this variance.
Okay, yeah, so very interesting. We also came across in the process of going through your application, that same question. So why is this an existing non-conforming structure? One of our members cited something in the zoning law that business light does allow residential property. Is that correct, John?
Yeah.
You saw that.
That's what this book says.
Yeah, okay, right. So I guess the question to the building department then, is this an existing non-conforming structure?
It is, but they're expanding it. So I cited the code in there
Right.
where it states that if you expand a non-conforming structure, it is not allowed to be expanded
But what makes it non-conforming?
because that district is switched to a business light in the 2017 code book. So it's
The
not.
building is non-conforming?
Yep. In a
because-
business district, you can't expand a residential structure.
Right, if I could add, without having looked at this application, so I don't know the merits of this one. In the past, this board has addressed existing residential structures, and I believe it was in a business-like district. Certainly, you've addressed non-conforming structures that are seeking to expand. Put on an addition, put on a deck.
Right.
And that was considered not compliant because you're looking to expand a non-conforming structure. This board has addressed that scenario through an area variance. Not a use variance because it's existing, the use is existing, but through an area variance to allow the area expansion. I'm not sure if that's applicable here. Is the issue, Mike, is the use allowed?
No,
Or is it?
I know Wendy had talked, she wasn't sure if it was going to be a use or an area variance. So.
And fill out both portions of the application.
Right, you did that.
Yeah, 'cause-
That's why I'm in front of the board, get educated.
Well, right now, its last use was
Two-family.
rental
Two-family rental.
property, right? And now you want to just change it back to just a
Single family.
single family, but the rental was still residential. To me, I can't wrap my head around a non-conforming structure. Because I want to know, like, what is wrong with the structure that makes it non-conforming? The fact that it's in a business light, well, I can't understand that. I mean, is there a problem with the setback from the road?
Nope.
Setback from the side?
It's just, if you look in the definition,
Yeah, I'm reading it
yeah.
here.
I read
It's
that.
Section 2.
Yeah, I read that. I didn't. It
So,
still
I mean,
didn't make
technically,
any sense
that's,
to me.
yeah.
We're also not attempting to do any addition to any of the setbacks. 6
Right.
acres behind that.
Yeah, you're just going up.
Just going up, right.
Addition that is dilapidated that we want to remove and slightly expand the existing.
Make it 2-story,
Yes.
because right now it's 1, right?
Right now it's.
What I was looking at on page 33, it gives the definition for or gives the purpose of the business, light business. It says the BL district is intended to support density, single-family resident development. I don't see how this doesn't fall into that category.
Business. Go ahead.
All I would advise the board is, if you've heard me say this in the past, what you're doing is looking at the zoning law, the definitions, and trying to interpret what that means. That's the code enforcement officer duty to first make that determination. And if the property owner, we heard it earlier tonight, disagrees with that, they can appeal to this board. So these questions about what variance, use versus area, that's initially a determination of the code enforcement officer, the building department. So if we're now faced with an application, and I can commiserate with your position, I wasn't sure, so I filled out all portions of this. The zoning board needs to determine what's the variance application in front of it, what's required. That's got to be first determined so the board knows what's in front of it. It's not your job to interpret the code and decide what variances are required. That's initially the building department.
And essentially, they weren't expanding the front porch per se. They could just restore the building as it is. It states in the code that you can't enlarge a non-conforming structure.
Right, but they do want to, and that's fine, by adding a second story to the back.
So what is, he needs variance? Is that what it is?
Right, so does he need a use variance or an area variance?
I would say an area variance.
So we're going to accept, so then as a board, we'll accept your determination.
But if I just might clarify something too, though, that section of section 2 says non-conforming use of structures. So if section A is enlarging or extending structure, such structure should not be enlarged or extended beyond the present structure. But that falls under non-conforming use of the structure. So the key word to me is use. So I would lean towards it being more of a use variance, that we want to change it based on the use.
Back to a residential.
You know?
It was residential before.
Yeah.
It was always residential.
Yeah, it's just the district has changed to a business light, unfortunately. I believe the next lot over is where it actually starts R15.
Which way? More toward,
Towards
Seven
going towards
or-
Grange, further out Grange.
it changes to what in R15?
Yeah.
Yeah, because I would have noticed that.
Yeah.
Yeah, resident to the right, resident to the left, resident across the street.
Right.
No commercial there.
Right, just in general, so you kind of get the sense of why this is even an issue. When a town looks at its zoning map, it can certainly make changes to that. So you heard tonight that the Brunswick zoning law was adopted in 2017. That was not just the zoning text that was amended, but the zoning map was amended. And what can happen in those cases is properties that had been in one zoning district are now placed in a different zoning district. Properties that were residential may have been placed in a business-like zoning district. When that happens, and the historic use is not consistent with the new zoning district in which the property's been placed, it becomes what's called a non-conforming use or a non-conforming structure. You're allowed to continue that use, and that's your property right. But there are limitations on what you can do because you're now non-conforming. That seems to be what's going on. Doesn't mean you don't have a remedy. You just got to figure out what's the correct remedy. Is it an area variance, depending on what you want to do? Is it a use variance, depending on the historical use and what you want to do? That's the first issue, that's the threshold issue. To consider that. Once that's done, then the zoning board can act and move forward.
Can it be both?
There are situations where things may need both, depending on what you want to do and in what type of structure you want to do it. So I'll give you an example. A house that had been a residential district, that may have historically been in a nice quiet neighborhood, is now adjacent to what amounts to a commercial corridor. Okay, you can continue to live there, but it's now zoned for commercial. Well, fine, now I want to do something different. I want something to do with commercial, but it's not allowable use in that particular commercial district. Well, fine, you can do that, but your use would require a use variance. But then while I'm at it, I need to expand my structure because I need more room. Well, that might necessitate some area variances, so it could be both, depending on the case. Again, I apologize, but the first time I see it is tonight. That seems to be what's going on, based upon what the historic use was, the zoning district, what's being proposed. Those need to be considered to determine what variances, if any, are needed. That's all. And that's,
So when you
That's
look
not
at
the
the
board's
historic use, do you look at the last use?
yes,
Okay,
you do.
so it was.
Yeah.
It was rental.
And
Residential.
right. That's right. You look at the use that's in existence at the time the zoning is amended or changed. If that use was legal at the time and it no longer is compliant with the zoning, you can continue that use as non-conforming. You continue using that structure as non-conforming. But when you want to do something different, that's when the zoning law has to be reviewed to determine if any variances
Okay,
are
here's
required.
another question. So say you wanted, say we determined that it was a use variance because it had been rental property.
I'm going to hold you there for a moment, okay? And reiterate, it's not the board's job to determine what use variances are required. That's the code enforcement officer's job. Once there's an application for that particular variance made, your authority, your jurisdiction is to review that to determine whether it should be granted or not to determine what variances are required. If the building department determines a particular variance is required, a use variance is required, and the property owner says, I think you're wrong, then that can be an appeal. And then this board determines whether the code enforcement officer was right or not. None of that is in front of you now, because there still seems to be the initial clear
Okay.
determination about what variances, because it looks like every part of the application is filled out, and whether that's needed or not.
Can I determine it needs an area and a use variance?
In general, that could be the result, depending on the facts. But that's, again, that's a town building department determination. We've been through that. You can coordinate with the town attorney, because he'll assist you.
Okay, so then we need that determination.
Correct. We
Plus
need to
we
know.
need more documents.
Well, you need to make sure that the application as submitted is seeking only that which the building department says is needed, so the record's clear, the zoning board knows what its job is.
So it sounds like once the building department consults with the town attorney, Mr. Kiefer can then amend or reapply his application.
Yeah.
With
I'm
what
going
is
to
correct.
presume, did you already pay the application fee? Yeah, so it would be an amended application.
Yeah.
You would amend that and just clear up the record and get back in front of the board.
And then when you do get, come back in front of the board, if you could kindly present a rendering of what you, are proposing to build on the back, that's what it's
Yeah,
missing.
you said you had architectural drawings on that.
Oh, you have those? No, we didn't get any of those.
So
No, we
if-
just received 2 copies.
Okay, so if you can kindly make copies for 1, 2, 3, 4, 5, 6, please.
Absolutely.
Yeah, thanks, okay.
Mike, I have a question for you. Is, if this was the same exact dimensions, there'd be no,
No, it wouldn't. They would just get a building permit to rehab it.
okay. So they are, like John was saying, you know, putting it in as it sounds like it should be, well, in, I don't know, use or area. How is he going to be able to, like, shouldn't we help him establish that tonight, just to save some time about, like, filling out that application or doing the amendment?
Again, Mike, I have to advise you, that's not this board's, you don't even have the jurisdiction or authority to do that. That's a building department code enforcement officer determination initially.
So the clarification is Michael talk to the
Yeah.
attorney,
And get that
Decide whether
hopefully
it's
squared
used.
away.
area, both.
Yeah.
Michael get back to us. We'll add a few more pieces of the puzzle, and we can actually see what we're doing. We're literally looking to restore the thing as is.
Well, it's quite beautiful, and it's such a project, so I give you a lot of credit, and I'm so proud
I
of the
had my
project.
son prepare what it looked like, you know, when we bought it.
Uh-huh.
You know, and if you go by there now, you know, you can see, we're just trying to clean it out. My son,
Okay.
we're from Brunswick, we grew up on Eagle Mills.
Yeah, you have a great
We got
heart,
baby
too.
number 3 coming on, and we
Good
need to
job.
get this property nice home. You know,
Yeah, terrific,
We're
yeah.
gonna do whatever it takes to.
It's a wonderful
Follow-
project. I look forward to seeing how it's gonna go, but in the meantime, yeah, continue coordinating with the building department. We'll settle that, what you need, and what particular pages to fill out.
Thank you.
Good.
And we'll be able to get on the docket for next month in order to.
December 16th. Right. And you'll hear from the building department about that confirmation. So this is not the confirmation that you're gonna be on for December 16th. You will get that from the building department.
That's just our goal.
Yeah, good goal.
Okay.
Okay, thank you very much. Have a good night.
They probably should watch maybe on the streaming, just so that you don't have to sit here for another 2.5 hours. Just run down when we call you.
That's okay. We got patience. And thank you all.
Okay,
Again.
thank you. Are there any other items of new business that you'd like to bring up? Otherwise, I'll make a motion to adjourn tonight's meeting, November 2nd.
I'll second.
Thank you, Bill. All in favor?
Aye.
Good night, thank you.
No, I just saw in that section at the top even where it said use, you know, so I figured it was a grant of the use.